Yeah, so I was asked to talk about the EU-US data transfers. I guess everybody in the room had something to do with this, and sorry for on the one hand for like wasting hours and hours of times, but at the same time we generate jobs. I sometimes feel, so you know they can look at it different ways. Quickly, just for the presentation, I would do a quick recap on what did we have in the Schrems 1 and 2 discussions. I used to call them Privacy Shield and Safe Harbor decisions, but I failed in trying to brand it away from my name. And then finally, I would like to go over to what is the new deal and how is that going to work better or be easier. So if you look at the old deal, we basically have to look at US surveillance. And fundamentally, what came out of the Snowden slides was that there's two ways of surveillance. The one is upstream, which gets the data on the backbone of the internet. And then you have PRISM. And upstream is kind of surveillance that we know in other countries as well, that they basically try to kind of see whatever goes through their traffic. But what's really interesting in the context of the US is PRISM, because we know that basically the US is hosting a big bulk of the, at least Western data, and has direct access to that data. And through the PRISM program, which they now call downstream actually, they have direct access to the data that's held by the big tech companies. What's important to note here is all these slides are more than 10 years old. And we all know how technology evolves and changes, so we can pretty much think that there's probably a lot more going on than Snowden disclosed, unless the US has stopped developing anything. So we can expect that this is a bit of an idea of what's possible, but that's probably not what's currently going on. There may be much more going on right now. What's interesting with the part of especially PRISM or downstream surveillance is that, as they have it in this wonderful slide here, that there is usually no SSL encryption. So typically these companies have the data in the clear or have the encryption keys. And that means that there is these technical solutions that around usually fail here. As an underlying topic that we need to understand a bit is what is this US law that allows that? And I think it's important for two reasons. One of it is one side is it's a really extreme law. On the other hand, it does not apply to everything. So it's not like the whole US is terrible, but it's also not, oh, there is like some solutions, it's all wonderful. So in very simple terms, FISA 702, it's also codified as 50 US Code 1881A, is about 14 pages long if you print it out. I don't think any of these consultancy lawyers that does wonderful stuff on data transfers has actually read this whole thing, but they still do wonderful papers. If you read the whole thing and you try to get it on one slide, it's a lot of references back and forth. If you get to the gist of it, and it's not 100% accurate what's on this slide, but the big takeaways is that you need an electronic communication service provider. So it does not apply to every company in the US. It only applies to electronic communication service provider. That's basically telcos and cloud providers for anything that's relevant. There's some niche topics as well. The other thing you need is foreign intelligence information. That's it. That's the two things you need for surveillance. You do not need a crime. You do not need a judge. You do not need probable cause. You do not need any of the stuff we typically have for wiretapping. And that is the really interesting thing about that law. And foreign intelligence information has a couple of definitions, but the broadest one that I usually cite is information that relates to the conduct of the foreign affairs of the United States. Pretty much anything that they're interested in. And what's important for a lot of businesses, this is not just a privacy discussion, it's information. It's not personal data, it's any information. So if there is areas, typically, you know, aeronautics, oil companies, whatever, where the information is more interesting than the individual people, that is also allowed under that data. So you may be in charge of security in your company. That may be a bigger topic that goes beyond the GDPR issue because it's a security question as well of can they access this data or not. Now, the US usually says that there's a wonderful court that oversees all of that. Most of the stuff underneath the line is basically classified. Some of that got actually published, so we do have an idea of what it says, but only in individual instances. Now, this FISA court does a certification for 1 year. They do not review the individual surveillance. They certify the whole surveillance system for an entire year. And part of that, and the most important part of that, is so-called minimization and targeting procedures. Sounds great, but what does this do? It basically separates the data stream into American data and non-American data. That's fundamentally what this law does, is basically it splits between US persons and non-US persons. Why is that? The Fourth Amendment to the US Constitution would say that all of that is unconstitutional because you do not have a judge, you don't have probable cause. That's really the interesting thing. We're actually on both sides of the Atlantic agreeing that this is unconstitutional. But the US twist to it is, it's great, the Fourth Amendment only applies to US persons. So we basically just filter the data of the Americans, don't touch it because that would be unconstitutional. And then the data of everybody else, including all of our wonderful allies that we love so much, you can do whatever the fuck you want to do. That is fundamentally how this law works. And there is then a so-called directive that goes to the service provider, and that requires them to open up something like an API. All of that is confidential, so not even the people working at these companies are allowed to know that this happens. We had these wonderful situations where I think executives from Google were at the in the European Parliament hearings and said, "No, we're not doing that." I was like, either you got the clarification in the US that you can actually access it, then by law you have to lie about it, otherwise you go to jail for 10 years, or you do not have that clearance. If you don't have the clearance, why the fuck are you telling us that this does not exist because you're not allowed to know about it? So it's a situation where whoever is sitting there cannot really tell you what's going on there, and they're not allowed to know. And that is fundamentally how the system works. That is also interesting because there's only one directive per year. And that allows these companies to say, oh, we hardly get requests. Last year, we only got one request. But under that one request, you have to give basically any data back that the US requests for. So it's a lot of that is twisting words, playing around, and it works really well in PR because no one reads any of that. They just look at the headlines and say, oh, there's only like 1 or 2 requests, all fine. If you actually then look a little bit deeper, you realize, yes, you only need 1 request per year to get access to everything. So that's fundamentally FISA 702. If I'm that little Austrian smiley down here, I used to have a contract with Facebook Ireland. Data went to Facebook US, and basically the data got captured twice, prisoned them upstream. That was done under FISA. And then there is a so-called Executive Order 12333. I'm going to get to what an executive order is a bit later. That also allows surveillance, but basically in the cooperation with a company. So FISA allows you to force a company to comply and give you that data. 12333 basically allows, if a company voluntarily works together with you, to capture even more than that. We typically focused on that mainly because our assumption is that most of these big tech companies are not interested in complying. They just have to under the law. They typically are not, willing to do that, at least after the discussion of the last 20 years. But that's the reality that we have there. Now, there is PPD 28, which also limits that. So it's kind of technical because you have to, as a lawyer, read these 3 instruments together, overlap them, and then see what kind of falls through and doesn't fall through. So it's about, I have to guess, about 50 pages of text that explain to you if you can actually have surveillance or not. But the end result is the slide before. If you're not a US person, they can task you, and that's it. Now, what is the EU side of the story? Also rather ignored is the general rule in the EU has been ever since 1995 that there is an export prohibition on personal data. So ever since we had the old directive, the rule was you cannot export data outside of the EU. Why? Because if you would have all these protections in the EU and you basically send it to some other country that doesn't have the protection, the whole system would fail and you could just move it out and do whatever you want to do. Now, obviously there were the derogations for, in simple terms, necessary transfers. Like any lawyer that works in that area would probably grill me for that term, but it's simplified Article 49 if you really need to send data abroad. That is the fundamental rules, but we have kind of exceptions, which is especially relevant for outsourcing. And typically what we do here is that we expand the GDPR rules to another country. So we kind of say if the other a company in another country or another country as a whole follows the GDPR rules, that's fine. We don't have to build up artificial barriers. Now, for example, if we have Switzerland and they have a similar data protection act, we can say that's part of the privacy bubble that we have. There's data transfers, everything's fine, yoo-hoo, and we can yodel. Last thing, that the other option that we have is contractual. So if we have a country like the US where there's no data protection act, so we have a vacuum in that country, you can fill a vacuum with contracts because there's freedom of contract. You can contract for anything you want. And you basically put in different contractual arrangements, which is the standard contractual clauses, privacy shield, BCRs. You put European privacy law kind of into the contract and thereby contract a person in another country to follow European law. It's a bit like if we have, I don't know, organic bananas and someone in some third country grows them, we certify them as organic as long as they follow European rules, even though that may not even apply these rules in this country, but we kind of recognize that they follow that, which makes a lot of sense. We also supported all these instruments, the SECs and the BCRs, in the litigation. We were actually in the middle of the Schrems II litigation. Some of them said these should all fail as well. We said, no, that's fine, can work, that's all good. The problem that we have with the US is that as an American company, you signed these SCCs, Privacy Shield and so on, that kind of comply with the European request for privacy, but at the same time you fall under this US surveillance law. So you're simply in a clash of jurisdictions. If you take anything away from this presentation, this is the slide. This is fundamentally what the issue is, the underlying issue is for years. It's fundamentally that two jurisdictions have the opposite thing that they want from a company, and as a company, you have to comply with one or the other. At some point, there's just a conflict of jurisdiction. And that is something that we cannot really solve. There's too much law. So I always explain it that way. If there's two trains colliding, you have too much metal. And if you put another piece of paper in between the metal, that paper is shredded. But that is fundamentally what we have with the transfer regimes. We just basically put another and another and another transfer regime into these colliding trains. There's just too much law, and adding another piece of law is not changing it. It's actually physically kind of like the easiest way to think about it. But that's the part that the Commission has an issue about thinking. Now, if we now go into the case law, we know that the Court of Justice told us that there is a violation of the essence of fundamental rights. The reason I'm bringing this up for a second is typically we have a proportionality test on the European level. So under Article 52 of the Charter, we have some fundamental right, the freedom of speech or privacy or whatever it is, and we balance it to some public interest because none of these fundamental rights is absolute. We always have to do a balancing test. Typically, the Court of Justice in the privacy realm comes out somewhere in the red zone. So, for example, if we think about data retention, Vorratsdatenspeicherung, that's typically something that the Court of Justice said goes too far, we can't do that. This is the first time, actually, in the US that they found a violation of the essence of a fundamental right. In both cases, actually. And it's really interesting because that means that the court does not even engage in a proportionality test anymore, because they say what the US is doing is so fucking crazy and out there, it doesn't even lend itself for proportionality tests anymore. The only time where that is in law is torture. There is no proportionate torture. That's the only thing where you can do a proportionality test, but that is kind of where the Court of Justice put it. I did not think that they would go that far. Like, we argued it because from the case law, it would have been logical to argue. But my Irish colleague, lawyer, basically, when you're at the Court of Justice, you get the judgment like thrown at you, and then you have 20 pages, and you have to read it as quickly as possible. So he split it up, and he had the page where he's like, oh my God, we got the violation of the essence. But that means that's only 2 cases so far where that was found, which is these 2 cases. So the judges are very, very serious about this going too far. It's not something that you can like change with a little bit, like adding a little bit. That's the reason I want to have that slide here, is to make sure that we all understand that just a slight, change or amendment is not going to make it. You probably then, okay, finally you get it into the red zone, but that also makes the thing fail, so it doesn't really get you there. Now, if we look at the strategy that the European Commission applies to all of that, it's kind of nice to look back at the Privacy Shield. So the Privacy Shield was presented, and everything we got was this logo. And I was asking a person working at the Commission, was like, how the fuck did you come up with the word Privacy Shield? Like, I think the other topic was Privacy Umbrella was another idea. And people negotiating that told me they did not know about the name of the new deal that they're right now negotiating, because it didn't exist at the time. An American NGO actually made a Freedom of Information request in the US and got a negative answer by the US government with the argument, with the reason given, the record you requested does not exist. That was a couple of weeks after it was presented. 2 months later, we actually then got the text, and later was actually presented. At the time, the the European Commission has already put out the press release saying that the US authorities assured that there is no indiscriminate or mass surveillance by national security authorities. So everything's fine. If you read it a bit closer, they assured. The Commission never said they don't have that. They just said the US assured us they don't do it, which is like having China assure us that human rights are great in China. We have these assurances, but we all know, nah, probably not really true. And if you go into it, it's actually quite interesting, because the annex to the Privacy Shield decision already says that there is bulk collection for 6 different purposes. So the press release says no mass or indiscriminate surveillance, but their own decision says bulk collection. Now, there is an argument that bulk collection is something else than mass or indiscriminate surveillance. No one has ever explained to me what the difference could possibly be. But that is kind of like how this thing goes down. And when you go into it, it's collection in bulk for 6 reasons, including combating transnational criminal threats. So all you need is not a crime that crosses a border, just a threat of a crime that could cross a border. And for that, you can already do bulk surveillance. So just a Mexican walking along the border with some, I don't know, crack in his pocket is technically a transnational criminal threat because he could, like, you know, put it through the fence and then you have a transnational crime. So that's enough to actually trigger these possibilities. If you then look a bit further into actual US law, you see that the word bulk has a footnote. And if you follow the footnote, it basically tells you that they only call it bulk surveillance if they keep the whole data in bulk. If they just sift through the whole data in bulk to then find the needle in the haystack, that's not bulk surveillance. And there is no limitation on how long you keep the haystack. So as long as some point you try to get something out of the haystack, it's not bulk surveillance anymore. So even these 6 limitations do not apply if you later get rid of the haystack. But the Commission is telling us no indiscriminate or mass surveillance in the US, and assurance. And that comes out of a letter from these annexes. That is fundamentally how this system works. It works for a commissioner to sit out there and say, woo, I have a solution. Now, what are the practical consequences for the time being? Basically, this expansion of data transfers under these different rules, we right now have a major problem in the European Union. That does not mean that any data transfers cannot go. Like, for example, if you have, like, I don't know, you book a flight or you send an email to the US or you have a hotel booking, that's all fine, that's a necessary transfer. When Schrems II came around, a lot of the crazy lobby lawyers, I sometimes don't know if they're lawyers or lobbyists, they're a bit mixed, they came around and said, oh, we're not going to be able to send emails abroad anymore, and, you know, all the world is going to go under. That's not true. Like, all of that is usually possible under 49. What's the problem is if you outsource your data to an electronic communication service provider, and that includes if their server is sitting in Frankfurt. Because the US surveillance law does not have a geographic limitation. It applies to any data globally. As long as an American company has possession, custody, control, that's the 3 magic words in US litigation, they have to provide that information. Now, there are solutions where the data is outsourced. For example, there was this German Azure solution with Deutsche Telekom holding the data. That could be a solution. It could even be within the group of companies that there's a subsidiary that is, for example, a stock company where there's no direct orders anymore. And then the head of the European stock company could say, I'm Microsoft Cloud, Europe, whatever, blah, blah, but I'm falling under European law. You only hold the stocks. You can't give me any orders. I'm not going to give you the data. That could be possible, and that would be really interesting to develop further. But so far, if you talk to the big tech companies, they're like, that costs money, that's annoying, it's complicated, and there's no enforcement anyway, so why should we? But there is some room for these solutions. Now, you could have the situation that you transfer data to a normal company in the US that does not fall under these surveillance laws, which is perfectly fine. If you have a subsidiary abroad that is not following any of these rules, and they don't themselves put all the stuff in the cloud, that could be a solution where you can have data transfers without any interference here. Now, enforcement, we basically I'm just going to go back. We basically went through that, and it was really interesting because they came up with all their different arguments on why all of that would work wonderfully. And a typical argument that they came up was their supplementary measures. And I don't know if you've all seen these wonderful documents that are around, but we went, for example, through the supplementary measures of Google, which is even on our website. It's about 30 pages of bullshit. It's literally not a single thing there that makes any sense. My favorite one is that they said they will put up a fence around their data centers and a sign that people should not enter, and that's a supplementary measure against the NSA. And I kid you not, that is not the most stupid one on the list. And the whole exercise was just to produce a list that's as long as possible, just to impress everybody about all supplementary measures, without really getting any solution. Another one was that they have AEC, I think, encryption. People in the room will know better. That's exactly the encryption that my phone has as well. Not going to help you if the NSA tells you you have to give it, otherwise you go to jail. But that's kind of the arguments that go around. And that worked quite well because everybody just was like, supplementary measures, sign it, goodbye, problem solved. Now, for the enforcement, we actually had 101 complaints that we filed across the European Union after the judgment came out. That was on Facebook Pixel and Google Analytics, just to find something that is easy for companies to comply with or change. It is really interesting because we saw very slow procedures. The DPAs were absolutely unwilling to really go for that. And we had them mostly closed because of compliance. So most companies just said, okay, I'll remove it, and then the case was closed. So it was interesting for us because we saw that the regulators are not really interested in moving forward with this, which on a larger picture is getting us to a very interesting situation where the legislator, they even passed Article 48, which was the anti-NSA law that they passed in the GDPR. And the judiciary is actually very upfront with this, actually quite bold, you have to say. But then the executive is simply not complying with it. And that is constitutionally, for me, a really interesting question of, like, if we have democracy, if we have 90% basically voting for the GDPR in the European Parliament, and all the member states voting for it, that's much more than most other laws ever got. But then the executive says, nah, I don't really feel like it. That's an interesting situation that we have here. Now, coming up, we did have some discussions about public tenure and requirements for public contracts. There were cases in Germany or France where that was actually an obstacle to international companies to get in the market anymore. What's really interesting, I think, in the future is non-material damages. So we have the first case by the Court of Justice saying that there's no threshold for material damages. It can also be a small damage if it's a small violation. And since the summer, we have collective redress in the European Union. So if you think about 1 million data subjects that could potentially, all ask for 100 euros, and you do the math, you end up with 100 million euros for a damages claim. That could get really, really interesting in the next couple of years when it comes to the transfers, especially because the annulments by the Court of Justice are retroactive. So if you relied on all these deals, you do not have a deal ever since 2000. And that could potentially be a rather interesting discussion to have. I'm not a big fan of actually going there personally, because I think the regulator should just take care of it and keep it in ordinary boundaries. But if that's not happening, that's probably where we're going to go, because it's just going to escalate more and more. Now, talking about the new transatlantic data privacy framework, I still have a hard time to remember the name, to be honest. But I realized the really cool kids on Twitter now call it TAT, which is apparently the way to deal with it. Where did that came from? So what I know quite well is the first day that Ukraine happened, the Americans walked into the room in Brussels and said, now we have to show that we love each other because Putin is going after Ukraine. And how better to do that than give us all your data? At the time when I heard that the first time, I was like, that cannot be real. But apparently that was the narrative or the thinking. That didn't really go far, but then basically there was a meeting between Biden and von der Leyen, and in that meeting they came up with the solution of all the troubles that lawyers could not solve for 1.5 years. That's, I guess, the reason because why he's the president and she's the head of the commission, because they can solve all these things in 10 minutes that no one else could solve. And after that wonderful meeting, we knew we were going to have that new deal. The new deal, again, only had 3 headlines. And then the headlines were gradually filled in the year thereafter, basically. If we go into it, it's a shitload of paper again. I think the idea is, again, no one is going to read it anyways. I don't know, has anybody read the whole deal? Executive order, everything? No, okay. One person in the room. and basically these principles work like that. So basically the commercial principles, which is what can companies do with the data, are exactly the same as the privacy shield principles, which are exactly the same as the safe harbor principles. Now the IPP, this American lobby/professional organization, has done a comparison, and the comparison is wonderful. They added the word US twice up here, and the footnote down here on the page 1 and 2. Page 3 and 4, empty, exactly the same as before. And on the last page, they added that there could be another body of enforcement which does not exist in reality, but it just opens the possibility for that. That is the new deal compared to the old deal when it comes to the commercial use of data. Now, if you look at commercial use of data, usually in Europe we need consent as the one legal basis everybody knows, or one of the other 6 legal bases that everybody else seems to ignore. And if you compare that to the privacy shield / TAT thingy, you only have an opt-out here. So even on Article 6, one of the most crucial things of the GDPR, you have opt-in here, consent, other legal basis. Here you have opt-out only for sharing the data with someone else or for changing the purpose. So as a recipient in the US, you only have to have somewhere on your website an option to opt out from these two processing operations. Everything else is always legal. You can do whatever the F you want to do with the data. That's going to be easy enough for the judges to say that's not essentially equivalent. Because you have to think that that's a sub-processor usually. So as a customer of some app, I would need to know that the app sends it to subprocessor A, that sends it to subprocessor B, to subprocessor C. Then I have to go to the website of subprocessor C, then seek an opt-out to make sure that my data is not shared with anybody else. Not sure if that's going to convince anybody. That's already on commercial stuff. There's a lot of other stuff where that's extremely different, but that's a nice example. Now, the biggest topic, obviously, was the whole discussion about the new executive order. And the new executive order is this. It's basically a signature on a piece of paper by the president. We all know Trump with his wonderful, big Sharpie executive orders. That is an executive order, and an executive order does nothing but, it's nothing but an internal order by the president. So it's like your boss telling you to do something or not to do something. That does not generate third-party effects. It does not allow your customer or some external person to sue you over it because you didn't follow your boss. That is an executive order. The US uses that a lot now because they cannot pass laws anymore because of their dysfunctional parliament situation. And that is fundamentally what this whole thing is based on. It is internally binding on everybody, but it's not for you as a person that is concerned or where your rights are violated, a possibility where you can actually go to court over. Now, what is in this executive order? Oh, first of all, they say, oh, there's this wonderful new executive order. It has all these wonderful things in it. What they do not say that this is the new one. There used to be PPD 28, which was the old executive order. And guess what? It's basically the same. This one is not that easy to compare as the one before because they really just took all the elements, reassembled them somehow else, and then passed it again. And there are slight differences. It's not easy to say that it's absolutely the same. But the difference is that the limitations are basically the same. There's slightly clearer languages in some parts, so there is certain elements that are better. What's interesting, there's even additional reasons for mass surveillance. So you remember the 6 points for bulk surveillance I mentioned before? They added 2. One of them is health crisis, so corona, or climate change. So we now can have bulk surveillance for climate change. I have no clue how they're going to do that, but I think the NSA is going to solve climate change. And the big part that was actually really interesting was that the necessary now became necessary and proportionate, and that was what was sold mostly. And that would be super interesting if it would have happened. Basically, in the European side, we know that FISA prison is somewhere at the violation of the essence of a fundamental right. Now, they say under the new executive order, the US surveillance will be proportionate. So it would have to be somewhere here in the green zone. But they also say they don't change any of this. How do you move something that is not changed into the green zone? You move the green zone. So fundamentally what they do is they say there will be proportionality in the US, but it will have a different meaning than in the European Union. That is how that's the miracle. That's it. It doesn't get more interesting than that. So that is kind of on the surveillance part, the big changes. Then on the judicial oversight, we basically have this thing that the ombudsperson that we used to have now becomes a CLPO. There's so many acronyms, I don't remember what it actually means. But basically, there's a new person and exactly the same system. So you will basically go to your National Data Protection Authority. They will raise it with the CLPO, and then you will get an answer. And the beauty of it, the answer is pre-described. It's in the executive order, the exact wording of the answer. If anybody's interested, I have a stamp here where you can basically rubber stamp that answer on your arms or whatever you want to have. And what they will say is that they will neither confirm nor deny that there was any surveillance, that they either did not identify any violation, or that they fixed the violation. But they will not tell you what of these things. Now, if you're unhappy about that, you can appeal it. The interesting thing is you don't know what happened in your case. You don't know why you appeal. So all you have to do is to write, I appeal. You cannot even give grounds for your appeal because you don't know what the grounds may be. And to have a court, we now have the exact same exercise a second time around, just that instead of one person, there's now going to be multiple people deciding about it. And actually, this is a tribunal, which we have in the European Union as well, but the European Commission insisted that this is called a court. So they changed the name to court, just to make sure we have a court. But these are guys in the executive. They're part of the executive branch. They will be independent for these duties, but not a judge or anything that we usually call a court. Now, if you go up with that to the Court of Justice, these judges will look at it and will probably be like, you want to fuck with us? We told you twice you can't do that, and now you come up with that and tell us this is a court? So that's going to be really interesting how the reaction is going to be, because it's a matter of authority of the court as well. If the Court of Justice tells us this cannot happen, and they come around with the third time with the same thing, if I'm a judge there, I would be personally offended. So that is probably another factor in addition to the legal arguments why I see a hard time that would ever work. Now, this is the wonderful stamp. If you're interested in it, it's going to be around. Then just a couple of examples why this is technically so bad. So for example, they say the executive order only applies to data that was transferred after July of 2023, which means that any data you transferred before, you would have to get back to the European Union, then retransfer it after the date to even make the executive order apply to your data. Just like, who came up with that idea? Why not just have it retroactive? But you know, there's even, if you go through the details, it's so easy to challenge as well, because I just need one dude whose data was transferred before that date, and poof. So it's really, really interesting how that came up. Now, this is going to be a ping pong. Going to get back to the Court of Justice. Here we go again. I know that is not very joyful, and usually you should end presentations with joyful, wonderful views to the future. I'm trying my best here. And so I think very long term, what we need to do is to get a global agreement, at least among the democratic countries, on how much we have government access, because we will simply have the reality that data will go back and forth beyond borders. And the system we have right now that is largely based on citizenship will simply not work. Because even as an Austrian, if the BND is surveilling me, there is no court I can go to in Germany either. And that is something that will not be sustainable in the long run. So we need a fix here on that level. That will probably take 10 to 20 years to get there. In the meantime, the cheapest fix would be to get 20 lawyers in the US, or 20 judges that actually say yes or no, would be the cheapest option for all of this. The second cheapest would be if we have EU segregation by the big tech companies. Not something I personally like. I'm more of a globalist and would love to have free flow of data and so on. But for the time being, that would be probably the simplest that we could have right now. And probably just transfer the data that's really necessary. I hope that was useful somehow, and I think we still have some time for questions as well. Thanks.